6342 2018. WBC 6342.
I'm just reading out the relevant portion. Therefore, the impugned order dated 6/12/2016, having been passed without fulfillment of the precondition of section 26(1)(f) of the said Act so and so, that is, without arriving a prima facie finding under section 3(1) and 3(3) of the said Act 2002, is without jurisdiction and as such is a nullity. Resultantly, the review order so and so is also null and void. Accordingly, in WPC 6348 of 2018, the impugned order dated 6/12/2016, passed by the CCI under section 26(1) of the said Act 2002, and the review order dated 8/8/2018, passed by the CCI, stands quashed and set aside. Consequently, in WPC 6342 of 2018, the impugned order dated 27/8/2018, passed by the CCI, imposing penalty to the tune of rupees 5 lakh under section 43 of the said Act 2002, also stands quashed and set aside. Hence, the two writ petition succeeds, disposed of.
Obliged. Obliged, Your Lordship.
There were two IAs, right? Both the IAs accordingly stands disposed of.
Lordship, item number 33, Your Lordship. Item number 33.
30?
33, Your Lordship. 33. So this matter has been finally heard by His Lordship, the Borua, Your Lordship. And the order was dictated also.
30?
33, Your Lordship.
33 has come up for orders today.
Lordship. But that matter has been finally heard. And
Mr.
the
Counsel,
order was dictated also.
in this court, when matters are listed for orders, I prefer to see the file and give the order when the matter is done. You ask one of your junior to be present. It will be called. Do not make any mention out of turn for order matters. Ask your junior to be there.
Lordship.
May it please your lordship. My lord, an interlocutory application was filed on 27th August, my lord, in connection with item number 7 before lordship. My lord, that is to come, my lord. That has not come before lordship.
IA has not come.
I has not come. Though requisition, I am seeking the.
All right.
I'm obliged, my lord.
May it please your lordship. My lord, I have filed an IA application in a old second appeal, which has been compromised in between the parties. So this matter will kindly be listed, my lord.
Senior bench, Asana? There's a senior bench.
No, my lord, this bench is not sitting. I advanced to mention before your lordship.
All right.
Mr. Obliged.
Tomorrow. You want it tomorrow?
No, my lord, on the 3rd of 9th.
Okay.
May please, Your Lordship, I beg to mention for
May please, Your Lordship. Your Lordship, I beg to mention item number 23 of today's daily list.
It's an order matter.
Yes, Your Lordship. But Your Lordship, small prayer, Your Lordship. Mrs. S. Roy, Your Lordship.
Wait for your turn. Next.
Okay, Your Lordship.
No exception in order matters unless it is going to be withdrawn or infractious. So please do not waste the judicial time. Yes.
My lord, I beg to mention for listing of this matter, Your Lordship.
Next.
Your Lordship, I would like to mention an item for listing.
Listing when?
Your Lordship, anytime next week.
All right. All prayers for listing, please give it to the bench.
Obliged.
Assistant.
May I please, Your Lordship? Lordship, with the consent of the other side, I beg to mention item number 14, admission matter, Lordship. Lordship, my senior is not well.
1-4.
1-4.
In item 14, your name?
Air Shom, on behalf of Ardev.
Have you informed Mr. Chandak?
Yes.
You've been informed?
Yes, I was informed.
Lordship,
No objection? No objection?
No,
As prayed for by MS?
Ardev.
Ardev, Learned Counsel for the petitioner, with
Lordship.
consent from Mr. V.K. Chandak, Learned Counsel, appearing on behalf of the respondent, list this matter
After 2 weeks.
2
Lordship,
weeks on a
interim
date
order.
to be fixed by the registry. Interim order, if any, shall continue till the next date of listing. Stop.
Lordship, will
You make your prayer at one go. And when the court is dictating the judgment, do not interfere. Wait till the court finishes and then say what you have to say. All right?
Your right.
Yes. Yes, Mr. Chandak, anything?
19,
It will be given by the registry.
Okay.
Yes. Next starter, please.
May I please your lordship? Lordship, I beg to mention item number 26, lordship. Lordship, appellant has expired.
26.
Yes, lordship.
Yes.
Appellant has expired, lordship, and we are process of filing substitution petition, lordship. Lordship, kindly matter later after 2 weeks, lordship.
It's an order matter. Wait for your turn. Yes. Rupak. Yat Kumar 1, 2, 3, 4. Sub disposals. Huh? Transfer petition.
May I please?
What ground?
Lordship, petitioner is the wife of. Petitioner is wife, my lord.
Yes.
And the case has been filed in the near about 100 kilometer distance, my lord. She residing in a remote area of.
When is the next date?
My lord, for the next date, I have to take instruction, my lord.
Huh?
I have to take instruction for the next
All right,
date.
I am issuing notice.
My lord.
Heard, Mr.
M.H. Soikia, my lord. M.H. Soikia.
M.H. Soikia, Learned Counsel for the petitioner. Stop. This is a petition under section 24 of CPC 1908 seeking transfer of FC civil case number 449 of 2023 from the Court of Principal Judge Family Court Kachar, Silchar to the Court of District Judge Karimganj. Issue notice returnable 4 weeks. Steps by registered post AD within a period of 1 week from today. List after 4 weeks on a date to be fixed by the registry.
Deeply obliged, my lord.
Legal aid counselor list consult. Legal aid counselor এখন list নাই. None appears for the petitioner when called. It appears that MSP Das, legal aid counsel, was appointed to appear for the petitioner in this matter. However, since the said legal aid counsel is absent when the matter is called, this court considers appropriate to change the legal aid counsel and appoint MS I think Dipanjali is there. No, legal aid counsel now. D. Deka Raj Borpuchari. Okay, as legal aid counsel. Registry to provide copies of the petition to the appointed legal aid counsel. List after 1 week on a date to be fixed by the registry.
Number 5.
There's a new list, both the legal aid as well as for amicus. Yes.
Please, your lordship, this is the petition.
This is what a transfer. This is revision petition.
I'm challenging the order and judgment passed in the land grabbing case. Since there is no special court, appellate court for the challenging the judgment and order of the land grabbing case, so I have invoked this one, Article 227, and the impugn order and judgment is given in Annexure 1 and 1N, page number 25 to 38.
What is the material irregularity or error?
Irregularity is, your lordship, the scheme of the act says first the criminal liability has to be decided. After that, no, first civil liability has to be decided, then the criminal liability has to be decided. This is thing. While deciding the civil liability, the Honorable Court Honorable Special Tribunal has to call for the circle officer report. And circle officer report, in the circle officer report, three things are very much mandatory. One is ownership, second is possession, as well as the trace map. Here in this case, the learned special tribunal call for the circle officer report, and that report, perusing that report, the honorable court passed the order. But here, what is missed here is the evidence. Evidence part was missed here. Without
Anyway,
taking-
then I'll issue notice that interim not at this stage.
interim, why I am seeking interim by virtue of the section 10 of the proviso, because the appeal for filing of the appeal, it is a 60 days time. Already the impugn order was passed on 23rd
All
July.
right, that we'll consider
to
after
stay the
the.
proceeding. Otherwise, they will start the execution proceeding.
No,
This is
sorry.
what I'm staying.
Your name?
Morami Pathak, M. Pathak.
Heard MS M. Pathak, learned counsel for the petitioner. Stop. This is an application under Article 227 of the Constitution of India, seeking seeking quashing of the
Setting aside,
Hmm?
setting aside and questioning.
seeking quashing of the order
Dated
no. Impugn order and judgment, or judgment and order? Impugn judgment and order dated 23/7/2024, passed by the learned special tribunal Kamrup in land grabbing case bearing special LG case number 1 of 2023, whereby the learned special tribunal dismissed the land grabbing case filed by the present petitioner. Stop. You have filed the
Yes,
land grabbing case.
I'm the agreed party in the land grabbing case.
Issue notice, returnable 4 weeks, registered post AD within a period of 1 week from today. In the interest of justice, in the interim, this court stays the operation of the impugned judgment and order dated 23/7/2024, passed by the Honorable Court of Additional District and Session Judge Kamrup as special tribunal in land grabbing case being special LG case number 1 of 23 till the next date of listing.
Your Lordship, I seek apology for just this on typographical mistake in numbering the annexure. May I correct?
Yes.
I will request.
Listing after the returnable date, you list on such
I
and such.
filed a CRP for setting aside the order,
Impediment.
implement.
You wanted to implead.
In the party suit, my lord.
You wanted to be impleaded.
Yes,
That was denied.
yes, that was denied.
Then I'll issue notice right now. Item 6, Mrs. S. Goswami, Ms. S. Goswami, learned counsel for the petitioner, and this petition is filed under Article 227 of the Constitution of India, assailing the order dated 17/1/2024, passed in Miss J case 777 of 2024, filed by the petitioner in TS 269 of 2023 by Learned Civil Judge, Senior Division, Kamrup M. Issue notice, returnable 4 weeks, registered post AD, list after 4 weeks, and a date to be fixed by the registry. The IA ahile. The IA has not yet come.
My lord, I have a little submission, my lord. What had happened, my lord?
Anyway, I'm posting it on Monday along with the
Oh,
IA.
my lord, the urgency is there, my lord.
What is the urgency?
urgency is that the matter is posted before the court below, my lord.
When?
Today, my lord. So unless this petition is what had happened, my lord, on 21st.
IA is for what?
Actually, what had happened when the revision petition was filed, due to computer devil, a wrong synopsis was incorporated with my petition, my lord. So I made a prayer. I brought it to the notice of the Honorable Court that the synopsis is not appropriate. So this Honorable Court was pleased to adjourn the matter, and I have filed the correct, appropriate synopsis. And the rule now, the procedure is that I have to file an IA. That IA has not come. If your lordship is inclined to hear me on the merit of the case, my lord, then only the synopsis part, my lord. Nothing else is there to be rectified.
Monday. Let this petition be relisted on Monday along with IA.
IA number has not been given, my lord. Only 9825. That is the serial number.
IA is not registered.
Not registered as yet. 9825. That is the serial number, my lord. My lord, may I pay at 2 o'clock, my lord? May I at 2 o'clock, my
Monday.
lord?
Next. Verify কৰিব লাগিব that defect here procedural number to registered one.
May I pray before Lordship, this matter may be time being heard.
Yes, Mr. Das, recalling and re-examining of DW1.
That's correct, Your Honor. That's the situation. Because my case that it's a statutory right under section.
Very well, I'll issue notice at this stage. Heard, Mr. Didas, learned counsel for the petitioner. Stop. This is an by filing this petition under Article 227 of the Constitution of India, comma, the petitioner is assailing the order dated 18/7/2024 passed by the learned civil and assistant session judge number 1, Kamrup Metro, in Miss J case number 285 of 2018, whereby the application filed by the petitioner under section 137 and 138 of the Indian Evidence Act 1872 was rejected. Stop. Issue notice, returnable 4 weeks. Steps by registered post AD. List after 4 weeks and a date to be fixed by the registry.
Deeply obliged.
Amendment, Mr. Sahaiwala,
My lord.
was not allowed.
No, it was rejected, my lord. In fact, the defendants, none of the defendants had appeared. Once this has come up before the High Court, where Section 80 application was not filed and they rejected. So we came up and the court gave us the liberty, you go and do whatever you have to do. We did it. While doing that, we filed an application under Order 6 Rule 17 for amendment. So the court at the very nasal stage rejected it that you are amending the.
Anyway, let them come. Heard, Mr. A.K. Sahaiwala, learned counsel for the petitioner. Stop. By filing this petition under Article 227 of the Constitution of India, comma, the petitioner is assailing the order dated 24/6/2024 passed by the learned civil judge within brackets Senior Division Jorhat in Miss J case number 16 of 2023 passed in title suit number 74 of 2019, comma, whereby the petition was dismissed, whereby the petition filed by the petitioner under Order 6 Rule 17 was dismissed. Stop. Issue notice, returnable 4 weeks, registered post AD within a period of 1 week from today. List.
Interim order will be returned.
No, not
the simple reason is, my lord, once they will appear, they will
for
file
amendment. Yes. List after 4 weeks on date to be fixed by the registry.
Then a shorter date, can I pray, my lord?
3 weeks.
Obliged.
Yes, what is this petition?
Lordship, may I please? Lordship, I have taken the contact of my learned senior brother. The matter may be taken up on 5th.
Brothers is this side, not that side. He's your friend. Yes.
The adjournment is necessary, Lordship, up to
Mr. Roy,
I have no objection. Only
as prayed for by the learned counsel for the parties, list this matter. When do you all want it?
5th of September.
Lordship,
5th September?
Till then, Lordship,
No, nothing till then.
No, Lordship, please do it.
No, if you are...
No, I am not praying for any stay or anything.
Yes.
Argument is fixed before the learned appellate court tomorrow. That may be deferred
So it will automatically defer.
You make a submission.
Yes.
The list list on
5th of September.
5/9/2020.
No.
Yes, Mr. Chaudhary.
My lord, I'm sorry, I could not comprehend. Is it item number 11?
Yes.
My lord, this application, revision application was filed by the petitioners.
Sorry, I didn't get you.
My lord, this revision petition was filed by the petitioners only seeking for a direction from this court for an expeditious disposal of the execution case. An arbitral award was granted in favor of the petitioner in the year 1999.
Service is completed, Mr.
Service is
Chaudhary?
completed, my lord. There, a liquidator has also been appointed on behalf of the respondent cooperative society. The liquidator's report is at flag M in the along with the record.
Your the prayer in this petition is for an early hearing
My lord, expeditious disposal
of the execution.
of the execution petition. I am told that recently some developments have taken place.
Can this court direct that, Mr. Biswas? The execution court will proceed in accordance with law.
I have reservation with regard to that direction.
Absolutely, because how can we dictate them unless some glaring something has been shown?
My lord, the liquidator was appointed long back. He has also agreed to the fact that the award, if the petitioner is entitled to the amount in the award. His report is also there. He has appeared
Maybe,
before-
but Mr. Chaudhary, where is the prayer?
The prayer, my lord, is at page number 15.
I'm sorry. This prayer, I don't think is maintainable.
My lord, otherwise, if I'm allowed to please, the Supreme Court has time and again stated that the difficulty of a decree holder.
You cannot simply rely upon a decision of the apex court and say the same is applicable in a case where otherwise your petition is not maintainable. Has the Supreme Court said in any case that in a revision petition,
Not particularly,
then
my lord. Not
the issue right now is about the maintainability of your revision petition? What is which order have you challenged? There's no order.
There is no order, my
Then-
lord, but the successive reports have happened is that since 1999, the decree holder is languishing like that. Even the original decree holder has passed away and now his son has stepped into his shoes.
This is an application at 227.
227, man.
Yes, what is the error apparent? Nothing. And you simply want a direction that this court direct the execution court to expeditiously proceed. How can this court grant that order? You want the dismissal today, or you want to do some homework and try your
My
luck
lord,
on another
may
day?
allow me some chance. Allow me one that.
This court has reservation as regards the prayer sought for in the revision petition. Stop. However, upon the prayer of Mr. N. Chaudhary, learned counsel for the petitioner, the matter stands adjourned to such and such date.
Deeply aware.
Service is completed, Mr. Viswas?
Yes, sir.
Completed?
Service is completed. We have taken the justice service and it has been completed. Now, I am before your lordship with regard to an application which we filed seeking amendment of my claim, which was rejected by the trial court.
Amendment to the plain.
Yes,
That was rejected.
that was
Against that, you have filed this.
Yes.
This is a
The
revision petition under
impugned order is at page 60, annexure E, your lordship.
this revision petition is under
Uh,
227. 227. Yes.
227, your lordship.
Yes. Where is the order?
The order is at annexure E, page 60, your lordship.
Page 16.
Yes, and the application by which, on
Mr.
the
Biswas,
basis of
page?
which your lordship will find annexure C is the application by which we had sought for the amendment, annexure C, page 41, and on the basis of this application, the impugned order has been passed. Now, what has happened, I'll just place a background, Your Lordship.
Just a minute. Let us see the impugned order. Where is it?
It is page 60, Your Lordship. Annexure E. 60, Annexure E. Order dated 7/4/22.
Yes. Relevant portion?
Yes, the relevant portion, Your Lordship will find at the last page.
68.
Page 67 is the
All right. Just read.
second para.
I have thoroughly gone
through the sprint, the petition for amendment and the written objection. After going through the same, it is observed that as the contested by the learned counsel appearing on the before, there is no averment in the plaint as to the prayer or proposed prayer number such and such to be included. Now all the, it is a quotation of the, what is up. Then now all the necessary material should be pleaded by the party in support of the case set up by it. No party can be permanent. He has gone into the merit of the plaint.
According to him, you are seeking to bring a new prayer. However, there is no pleadings in support of that prayer, either in the
He has gone
original.
into the merit in this. What has happened is, the case is between the brothers and sister. The plaintiff is the one of the sister, and the defendant number 1, 2, and 3 are the other brothers, and the defendant number 4 is the other sister. Now, it is a suit for partition. Now, during the course of the proceeding, the plaintiff came to know, means after an interim order was passed in favor of the plaintiff, the brothers had executed 2 sale deeds, selling off a portion, trying to sell off portions of the land. So the plaintiff wanted to bring those sale deeds into the subject matter of the partition, seeking a stay on that. And those 2 sale deeds schedule was inserted as schedule 2 additional schedules. Now, those are necessary for the proper, because it would be a multiplicity of suit if the partition is.
I have understood that, but what I am asking you is that are you in the proposed amendment? Yes. Are you proposing to bring those averments, or you are simply proposing to add a new para?
Adding paras, Your Lordship, the prayer,
So
that is
because you see, a reading of the impugned judgment shows that it appears that neither there are any averments in the original plaint, nor in the proposed amendment you are making any averments, but simply you want to insert.
We
Now
make the addition.
Now in that, of course, there has to be some foundation, correct?
Yes. So
now,
we have stated with regard to the sale deed, we want to challenge.
No, but what about the foundations, the pleadings?
The foundation, it is there, Your Lordship.
Are they part of the proposed amendment?
Yes, Your Lordship will find.
Yes. Because otherwise, amendment certainly, I don't see a reason for not granting.
Page 41, if Your Lordship.
The suit, isn't it?
Page 41, if Your Lordship.
Yes, I have 41.
Page 41, Annexure C. This is
I have it. I have it. Which paragraph?
Your Lordship will find number 6, Your Lordship, para 6. The opposite party appealed from the civil judge against the Honorable passed an order such and such was trying to forcefully dispose the plaintiff from the plot of land covering by such and such. On 18/12/2017, the opposite party illegally and with conspiracy.
No, but you see, what is the proposed amendment that you are seeking is at page 43.
Page 43, correct. It is necessary to enclose the schedule.
And it is necessary to add schedule so and so. And
these are the schedules thing, and the prayer portion we are challenging.
But where is the averments? The averments are not part of the proposed
page
amendment.
46, Your Lordship.
40?
Page 46.
Yes.
The plaintiff has not arrayed the co-pattadars whose name is included in the documents and the beneficiary as due party. The newly implemented defendants are included as performer such and such. They are such and such. The purchaser are made defendant number such and such. It is there. The newly implemented prayer is issue a direction that the registered sale deed executed by the defendants are illegal, and Sri Kamal Das and such have no right and interest. The defendants have illegally sold the land under Patna number that is specifically mentioned in para 2046.
Yes, I've read it.
It starts from 43.
Yes, Mr. Viswas, I've read it. Respondent 6 to 18 were struck off, right?
Yes, Your Lordship.
And 5 refused.
Yes. And the others, I have taken justice service, which report is there, Your Lordship. We have filed an affidavit to that effect on the service.
All right. Heard Mr. A. Biswas, learned counsel for the petitioner. Just 1 second. So and so. None appears for the respondent when the matter was called. Stop. It appears that though notices was duly served and completed in respect of respondent numbers 1 to 4, and is Mr. M. Das appearing for them?
No, Your Lordship. No one is appearing.
None represented the aforesaid respondents today when the matter was called. Accordingly, the matter is taken up for admission hearing as directed by this court earlier by order dated 6/8/2024. This petition is filed under Article 227 of the Constitution of India, read with Section 151 of CPC 1908, assailing the order dated 7/4/2022, passed by the Court of the Munsif Tihu in TS 05/2016, whereby the application filed by the petitioner / plaintiff under Order 7, Rule 17 CPC, read with Section 151 CPC, for seeking amendment of the plaint was rejected. Stop. The case of the petitioner is as follows. The petitioner, as the plaintiff, has instituted a title suit being TS number 5 of 2016 before the Court of the Munsif Tihu at Nalbari against the respondents, seeking declaration of possession, recovery of possession, partition, and injunction in respect to the suit properties mentioned in the schedule appended to the plaint. In the said suit, the defendants, after entering appearance, filed written statement cum counter claim. Stop. The suit is the said suit is pending in the evidence stage, correct? During the pendency, The petitioner on 2/7/2021 came to know that the defendants have in the most clandestine that the defendants have executed two different registered sale deeds in favor of two different persons for selling some portion of the suit premises. Stop. And in this regard, a registered sale deed bearing deed number 245 of 17 had been executed registered sale deed being 245 of 17 and sale deed being 246 of 17 have been executed. Correct?
Yes, Your Lordship.
Situated thus, it became imperative. It was imperative that the aforesaid facts be brought to the notice of the trial court by way of an amendment so as to effectively dispose the suit. Accordingly, an amendment application being petition number 125 of 21
Yes, Your Lordship.
was filed. Stop. He said, however, the learned trial on 7/4/2022 rejected the said application against which the present revision petition is preferred. Correct, Mr. Biswas?
Yes,
These
Your
are the correct facts?
Yes.
Heard before that, Mr. A. Biswas, learned counsel for the petitioner, submits that the amendment sought is necessary and essential for an effective adjudication of the suit. And since the said facts have come to light to the petitioner after filing the suit, the amendment petition warranted, and the amendment petition ought to have been allowed by the trial court. Stop. That's your submission?
Yes, Your Lordship. Because those are essential.
I've said it. I have given my prudent consideration to the arguments made by the learned counsel for the petitioner and have perused the materials available on record. Stop. Order. Amendment is order.
Order 6, Rule 17, Your Lordship.
Order 6, Rule
17.
Order 6, Rule, right, Marsha. Order 6, Rule 17 of the CPC is reproduced hereunder for ready reference. It is settled law that if application for amendment of claim is filed after commencement of a trial, it has to be shown that in spite of due diligence, it could not have been sought earlier.
The proviso is there.
Comma. The courts should allow such amendments which may be necessary for determining the real question in controversy between the parties, provided it does not cause injustice or prejudice to the other side. That's the law, isn't it?
Yes. A latest judgment of
Please give.
if I may.
Please give. You've highlighted it.
Yes. This is of 2022, Your Lordship.
All right, I'll just refer it. Reference is made to the decision of the Apex Court
22,
in the
16.
case of Life Insurance Corporation of India versus Sanjeev Builders Private Limited
And Your Lordship
another,
will find at para 71, last page.
reported in 2022, volume 16, SSC at page 1. Paragraph?
The guidelines have been framed here, summarized. Para 71, last but one page. Your Lordship.
Wherein the Honorable Apex Court has framed the parameters for consideration of amendment prayer. Stop.
In our case, Your
Paragraph
Lordship,
71 is reproduced hereunder for ready reference. The entire para 71, huh? Till 71.11 it is there. Keeping in mind the aforesaid parameters, let me now consider as whether the trial court has committed any error while rejecting the prayer of amendment as sought for. Stop. It appears from the judgment and order dated 7/4/22.
Yes.
7/4/22, that the trial court rejected the prayer for amendment sought by the petitioner plaintiff on the ground that there are no averments or pleadings proposed to be brought on record by amendment in support of the proposed prayer.
Yes.
I which is the prayer?
Lordship, you'll find that
The-
prayers are given.
Unga
Page
Tunia.
46.
Page
46, Your Lordship. Issue direction at the bottom, Your Lordship.
Yes. So these are the two new paragraphs.
Yes.
That
Paras, the reliefs that we are seeking, and the paras are before that, Your Lordship.
No, paras I've understood. I will quote that later. But the prayer is this too. Cha
Yes, Your
and Ja.
Ja and Cha, I think.
I think till Neo.
Yes.
Correct.
Yes.
4
paras are there.
Which are as hereunder. Okay. This is A to A at page 46 and 47. A to A. Okay. Stop. It appears from the amendment application, which is enclosed as Annexure C to the revision petition, that the petitioner plaintiff has specifically averred that
The defendants had illegally sold the land.
that since the defendants have illegally sold some portion of the land of the subject land, the amendment has been necessitated. Stop. Paragraph. This whole paragraph is to be. I think it will be better if I quote the entire paragraph 9. Or proposed
Para
amendment.
9, it is mixed up, Your Lordship. If Your Lordship.
Paragraph 12. Proposed amendment.
Yes, proposed amendment, the paragraph 12 is there. And in there, the relevant paras in which those insertions.
That
are
is
to
at
be-
46.
It has been stated. As Your Lordship will find, last line of para 9, if Your Lordship sees page 43.
That I have seen. But that is not an amendment which you are seeking.
No, these are continuing from that.
Perusal of the amendment application appears that the following amendment has been sought,
Yes.
which is averred in paragraph 12 of the said petition.
Yes, sir.
Stop. The paragraph 12 of the amendment petition is reproduced here under for ready reference. You just put the whole thing, whole paragraph 12. Then you write perusal of the aforesaid paragraph. It appears that the plaintiff petitioner, having come to know about the sale of the subject portion of land falling under the suit premises, is seeking to bring the following amendment so as to
This proper adjudication and
so as to have the entire facts necessary for effective and essential adjudication of the list in hand.
and multiplicity of avoid multiplicity of the suit.
Stop. It appears that the foundation for the relief sought is proposed to be is available in the proposed amendment. It appears that a case for amendment has been made out by the petitioner. Stop. Therefore, the order dated so and so of the trial court rejecting the prayer of amendment appears to be erroneous in the considered opinion of this court. Accordingly, so and so order is set aside. The impugned order dated 7/4/22 passed by the Court of Learned Munsif Tihu in TS 5 of 16 is set aside and quashed. Anything else to begin? Allowed.
Lordship, only the date may, because it has been kept in evidence, the date, your Lordship may direct both the parties to appear on a particular date as your Lordship.
Registry to intimate the order of this court to the office of the jurisdictional court so as to list for doing the needful. Let them do
Yes,
it.
sir. Highly obliged.
Disposed of.
Lordship, the respondent has filed affidavit of revision. I pray for giving 3 weeks time to file reply.
Respondent has filed what?
Affidavit of opposition.
Objection. Okay. की नाम तुम्हारा? देखा. Item 13, huh? As prayed for by Mr. S.P. Roy, Learned Counsel for the petitioner, list this matter after 2 weeks on a date to be fixed by the registry
Give us 3
to
weeks, sir.
enable the petitioner to file reply to the objection filed by the respondent.
Obliged.
3 weeks.
Interim to continue.
Interim, if any, shall continue till the next date of listing. Busy fast or cylinder? Busy fast or cylinder?
May it please, your lordship. My lord, as per the office note,
Yes.
the AD card on respondent number 1 and 3 has not been received.
All right. Dekha. Await service in respect of respondent number 1, 2, 3. List after 2 weeks on a date to be fixed by the registry. Striking out.
Yes, my lord. 1 week time affidavit we have received 19/8.
So you want some time?
1 week only.
for filing reply.
Yes. Next week.
Mr. A.K. Purkashta?
Yes.
Learned Counsel, as prayed for by Mr. A.K.
M.J. Burwa.
Purkashta, as prayed for by Mr.
MJ Burwa.
M.J. Burwa, Learned Counsel for the petitioner, list this matter after 2
Next
weeks
week,
on
my
a
lord,
date to be fixed by the registry to enable the petitioner to file reply to the objection filed by the respondent number
One.
one.
Lordship, in fact, that order has been given.
Let
In
them file. Yes. Yes.
May it please the Lordship. Lordship, we have filed this appeal denying our liability, Lordship. Lordship, in this case, the claimant has only made a bold statement in the claim.
You are the insurance company.
Insurance company, Lordship. That the
What about notice? This
Lordship,
has come for the first time.
First time, Lordship.
You are asking for. Are you pressing the IA today?
Stay no, Lordship.
All right, then I'll issue notice. Heard MS?
M. Cycle.
M. Saikia, Learned Counsel for the appellant. Stop. This is an application under Section 173 of the Motor Vehicles Act 1988 against the judgment and award dated 4/6/2024 passed by the learned member MACP number 2 Kamruk M in MAC case number 1908 of 2013 filed under Section 166 of the Motor Vehicles Act 1988. Admit, before Tara, just one second. Statutory deposit has been done.
Yes, Lordship.
It appears that the statutory deposits has been made on 21/8/2024. Stop. Admit. Issue notice, returnable 4 weeks, registered post AD within a period of 1 week from today. Mutation in revenue records was not considered. How can that be a substantial question of law? So, according to you, the trial court has ignored this law. Hmm? And the finding is in contrary with this. Where is that finding?
Lordship may see page 78, my lord.
78?
78.
Yes.
My lord, in the middle, in the instead case, the plaintiff has relied on the copy of Jamabandi, that is Exhibit 2.
Yes.
Lordship, what is?
Yes, yes.
Exhibit 2 to buttress their claim that the defendant is the owner and of the scheduled land for which the sale for agreement Exhibit 3 was executed. Land counsel for the plaintiff is relied upon the following judgment reported as year 1995 Supreme Court 1728. However, I am of the considered opinion that said judgment of Honorable FS Court is not applicable in the facts and circumstances of the instant case. My lord. My lord, here in this case, vendor of the
it was you, the plaintiff. As plaintiff, you had filed the suit for
specific performance of contract, being agreement for sale in respect of the suit land, my lord. And in support of my contention, my lord, I have filed the Jamabandi. Wherein, my lord,
to show that you are the
mutation of my vendor has been
to show your ownership.
Show the ownership of my vendor, my lord.
Of the vendor.
Vendor, my lord, who had acquired the property by right of inheritance. So he could not have any register sale it, as has been opined by the land court below. He ought to have a title document. My lord, but he has acquired the property by virtue of right of inheritance from his predecessor, my lord. So my vendor is not having any title document except my lord this revenue record. And nothing contrary to my pleaded case has been produced before the trial court.
All right. Read paragraph 3 of the judgment that you're relying. The judgment that you have handed over, you don't have a copy.
My lord. Yes, my lord.
Read paragraph 3 because let us see what is said. You have highlighted the head note. Head notes cannot be relied.
No, my lord.
Yes.
The land cultivated by the respondent belonging to his minor son was not as 18 but as a guardian of his minor son. The landlord allotted to his brother was evidenced by entries in the revenue records of rights, and therefore oral evidence coupled with those entries establishes that there was partition between him and his brother Ramchandra, and thereby the said land stood excluded. Lordship may kind of see next portion, my lord. Next page, my lord. I have highlighted too.
So before the trial court, the only document that you are relying is the Jamabandi.
Jamabandi, my lord, in respect of title of my vendor, my lord. With 7 except I don't have anything else. And this Jamabandi was not negated by the defendant, my lord, by contesting the suit. Matter proceeded next party.
Mr. Counsel, where is this entries in record? Where is it mentioned in the body of the judgment?
My lord, next page 3, my lord.
Yes.
I valid.
Yes.
even in the evidence of
The land allotted to his brother was evidenced by the entries in the record of rights.
Right, my lord.
So this is what? This is not a law.
No, my lord, your lordship cannot see the finding under those circumstances when the factum of partition was evidenced by entries of record of rights, which was maintained in official course of business. The correctness thereof was not questioned. Correctness of the entries was not questioned, my lord. It corroborates the oral evidence given by the brother and lends to assurance to accept it, my lord. In support of these entries, my lord, I have laid evidences too. And this was not questioned by the defendant, my lord. Only on this ground, my lord, my suit for specific performance of contract was dismissed by granting alternative relief of refund of money.
No, I'm not convinced. I don't think you have anything, Mr. Counsel. The trial court has, the appellate court has also considered the matter, reappreciated the evidence,
My lord.
and has come to a finding.
But without considering this position of law, my lord.
No, that they have dealt it. They
But
have dealt with it.
Your lordship can see page 115. Finding of the appellate court in paragraph 18A.
Where is the trial court's order?
My lord, this is.
Where is the finding of about this part?
My lord, that is. It starts from page 78. My lord, concluded.
No. 78 is part of the trial court.
Trial court, my lord.
And the appellate court?
Appellate court is, my lord, starts from page 101. And finding in respect of this particular issue has been recorded in paragraph 18A, page 115, my lord. 115, paragraph 18A, my lord. A careful perusal of the above judgment reflects that the Honorable Supreme Court has given observation that under Hindu law, oral partition is also applicable if the same is evidenced by entries in the records of right regarding such partition, and same has evidentiary value. In the present case in our hand is a suit for a specific performance of contract. It is not regarding partition and the entries thereof in the records of right. Entries in the record of right by virtue of partition is different from the entries in the records of rights under Assam Land and Revenue Regulation. As such, in my view, learned court has rightly held that the above case law is not applicable.
I have appreciated because that decision that you're relying is in the context of a partition.
No, my lord, my reliance is not in respect of partition, my lord.
I understand, but that decision that you're relying,
my lord,
your whole claim is that so and so is the owner on the basis of the Jamabandi. Correct.
Entries.
Now you want that to be accepted as an evidence,
my lord,
isn't it?
My lord.
And in order to show that this can be evidence, you are relying on the Supreme Court decision of 1995. But that decision has to be understood in the context.
My lord.
The context of that case is a partition. So there, even in oral family arrangements,
yes, my lord,
is sufficient.
Sufficient.
Isn't it? Now, here, nothing else have been brought except that in the record of rights, the name is there.
Revenue in the revenue record, entries are there. These entries have not been disputed.
These entries have not
been disputed, my lord. And these entries are relevant piece of evidence until and unless, my lord, contrary is proved. And these entries shows that my vendor has acquired the land by right of inheritance from his predecessor. So you don't have any title document. As
only two.
Only
substantial
two,
question.
my lord.
Perhaps.
That will also cover by suggested question number 3 also.
It was an ex parte suit.
Ex parte suit, my lord. Even ex parte appeal. In appeal also there was no protest.
AIR 2007, AIR 2017 Supreme Court confirmed 1246. AIR 2005 Supreme Court 1243. Supreme Court 1243. Internet to ভালকে কাম কৰা নাই
Lordship, can you see further observation of the appellate court?
One second. No, because I am considering that there is some substance because the ownership is concerned.
My lord.
This is why I wanted to see another decision, but all right.
My lord, one more.
You are Mr. Alam?
N. Alam.
Heard Mr. N. Alam, learned counsel for the appellant. Stop. This is a regular second appeal under section 100 of the CPC, read with order 42, rule 2 of the CPC, against the ex parte judgment and decree dated 16/3/2024, passed in title appeal number 303 of 2023, passed by the Learned District Judge Kamrup Rural at Amingaon, by which the appeal of the appellant stroke plaintiff has been dismissed with certain modification in respect of quantum of recovery of money. Stop. The appeal is admitted on the following substantial question of law, page 15 of Paba, number 2. One query. Roman 1 query. Issue notice, returnable 4 weeks, registered post AD within a period of 3 weeks from within a period of 1 week from today. Call for records from the Court of District Judge Kamrup Rural, list after so and so, date to be fixed by the registry.
Along with the record of trial court, my lord.
Will come case records.
Appellate court is remanded back the trial court record.
Remanded back along with trial court records.
One I is
From
there.
the trial court, as well as appellate court.
One I is there, my lord.
Later on,
Much.
in the I to be I lists accordingly go to the line. Yes.
May be question. This regular second appeal by the defendant's lordship.
Yes. Substantial question.
Lordship.
Page.
Page 4, lordship. In this case, lordship, plaintiff is the only daughter of the owner, lordship, along with 4 brothers, lordship. So
You are appearing for the
caveators.
All right. As far as today is concerned, you don't have much say.
My lord, we have to say something, my lord.
What?
Therefore, my lord.
What?
My lord, about the maintainability of this second appeal.
First of all, this court will see whether there is a substantial question of law
Yes,
involved or not.
Yes,
and as regards that, you don't have a say today. You will have all the say when the matter is taken up for hearing. You can argue that it does not involve a substantial question.
My
of
lord,
law. Now take your seat. Yes.
My lord, my
Take
argument
your
is-
seat for the time being. Yes.
Lordship, first substantial question of
Page,
law.
page.
Page 4, lordship.
Yes.
Whether the judgment and preliminary decree dated 7/3/2019 is at all passed in accordance with Mohammedan law giving 50% share to the only daughter plaintiff in presence of her 4 brothers, whereas as per Mohammedan law her specified share is 1/9 only over the total property of late Shohar Ali.
This is purely factual.
No, lordship, this is most important as because there were, lordship, 5 legal heirs. So property has to be partitioned into 9 shares. She will be entitled only 1 share. But preliminary decree was passed giving 50% of the property, lordship. So this is most important, lordship. Unless until there is a right title is declared among all the sharers, lordship.
Right, I'll come back in 5 minutes.
Lordship. Petitioner hearing কৰিব বিনা ফিজ আপোনাক মই ৰাতি ফোন কৰিছিলোঁ আপোনাৰ জাজমেণ্ট কমপ্লিট আছে পিছত মই বিচাৰি সব মিক্স কৰি দিছোঁ ইয়াতে মোৰ জাজমেণ্ট আপোনাৰ জাজমেণ্ট সব মিক্স কৰি দিছোঁ আপোনাৰ জাজমেণ্ট আমি চিনি পাই মোৰ জাজমেণ্ট আপুনি তাৰ বাবে আৰু কিছুমান এক্সট্ৰা আছিলে চ' সববিলাক বেলেগ বেলেগ কৰি আপোনাৰ আপোনাৰ বেংক খাতা ৰাউণ্ড বেংক খাতা ৰাউণ্ড আছে কিবা কিবি বেংক খাতা
বেংকত ৰাউণ্ড জাজৰ কথা দিছে নেকি?
Selby.
চেলভি নহয়, চেলভি আছে কিন্তু ডেট ইজ নট মেইন।
আৰু কি দিছে?
এটা আছে গোপাল লাল, আৰু এটা হ'ল নামবিলাক ভালকৈ উঠা নাই, চাম ভট্টাচাৰ্যী ভাৰ্চাছ ৰতন, আৰু এটা হ'ল আইনমন্ত্ৰী ক্লেইম কৰিলে 50% পায়, বাকী বাইকেইটা ল'ৰা ছোৱালীয়ে চাব দিছে।
Yes.
Lordship, as per plaintiff Lordship, her father died in the year 1976, Lordship, and suit was filed in the year 2014, Lordship. So there was no brother alive at that relevant point of time. Only we are the legal heirs from the brother side, Lordship. So she is the only daughter of Saheb Ali Sheikh. So her share is only 1/9, Lordship. The 4 brothers will take 2 shares each, Lordship. So according to Mohammedan law, she is entitled for 1/9 share only, and that was not taken into consideration by the trial court. Preliminary decree was passed giving 50% of the entire property. So
50% was given.
Lordship.
Where is that?
Trial court judgment, page 33, it starts. And last paragraph, Lordship, order portion, page 47.
Page 33.
47. Order portion, Lordship.
Yes.
In view of the above discussions and the decisions reached herein above, the suit of the plaintiff is decreed on contest without cost, declaring that the plaintiff has right title, interest, and possession over the suit land, which is specifically described in the schedule of
50%.
the Lordship. So my case is that Lordship, preliminary decree has to be gone.
You are for
the defendants, Lordship, legal heirs from son.
Oh, you are for the brothers.
Lordship.
So according to you, the plaintiff ought to have been given only 1/9.
Yes, Lordship.
This is your.
Yes, Lordship. As per plaintiff, Lordship, she admitted in her plaint that in the year 1976.
Where is that part?
Page 8, Lordship. Paragraph 3, Lordship.
Page 8.
8.
Yes, para 3.
This is her case, Lordship. Para 3, that Saheb Ali Sheikh, her father, Lordship, expired long back in the year 1976, and his wife Jamila Khatun predeceased him, leaving behind. So, Lordship, if we Lordship kept aside this wife part, Lordship, the Saheb Ali Sheikh expired long back in the year 1976, leaving behind 1 daughter and 4 sons. So she herself admitted that at the time of death of her father, there are 5 legal heirs, Lordship.
Yes. Which part of the
Mohammedan law says she, along with her brothers, will
where section? Section
63, Lordship, sharers.
Section 63 of the
Mohammedan law, Lordship.
It's not going to law. Total differences.
And according to Mullah's.
This 63 is
63 sharers, Lordship.
This you're referring to the. This is section 63.
Lordship will find
Yes,
table of shares is there, Lordship.
Yes. Father.
Daughter will get half share when there is no son, Lordship.
No son. And when the son, with the son, she becomes a residuary.
Yes, Lordship. So she will take one share and the son will take 2 shares, Lordship. There is a decision, Lordship. Lordship will find this is a decision of Delhi High Court, Lordship. Here exact is the situation. 1 daughter, 4 sons, Lordship.
You are insisting because I think only one
daughter
is the substantial question that you have given.
Yes, Lordship.
Perhaps only one is good enough
for preliminary decree, Lordship. And the first appellate court held that when final decree was prepared, I cannot challenge the preliminary decree. Section 97 of the CPC, Lordship. So 3-4 will be required, Lordship. This is a decision, Lordship, where it is a case.
So 2 issues are now involved. One is about the share and second about the maintainability of the appeal itself.
Lordship.
That is why Mr. Counsel was saying this is not
Yes,
appeal.
Lordship. His contention is that Section 97 debarred the appellants from filing any decree against preliminary decree when final decree was passed. But as per Section 97, Lordship, if no appeal was filed against the preliminary decree and if I file a decree against final decree,
we'll go to that.
Yes, Lordship.
Here in this in a Delhi High Court judgment, which para are you relying, Mr. Chaudhary?
No, Lordship, the entire case I am relying only because that in this case also there are same legal heirs. 1 daughter, 4 Lordship.
Which
son.
part, Mr. Chaudhary?
Lordship.
I don't want to read the entire judgment.
Lordship. Para 8, your Lordship will find.
Yes.
Section 97. Last part, Lordship, it is further settled under the Mohammedan law of inheritance that the share of a daughter in the property of her father is half of the share of her each brother. In this view of the matter, the appellant Bullan has been correctly held entitled to 1/9 share in the property along with her brothers. There is no infirmity or illegality in this finding as well. The same is accordingly affirmed. Here, Lordship, the first part it is written as he had 4 sons and 1 daughter.
Okay, now next part.
Next, Lordship, substantial question of law 3 and 4, Lordship.
Yes.
3, I am relying that whether the learned first appellate court is correct in dismissing the first appeal of the defendants against preliminary decree on the point of delay, whereas the delay was already condoned by the order dated 18/7/2022 in Miss Case number 9/2022. That order also I have annexed along with this memo of appeal, Lordship.
Delay already condoned.
Yes, Lordship.
And then what is number 4, section 97?
Whether the
where any
first
party aggrieved by preliminary
Lordship.
decree passed after the comment of this court does not appeal from such decree, he shall be precluded from disputing its correctness in any appeal.
Lordship. Number 5 is, Lordship, Order 41, Rule 31. First appellate court only on the discussion on
Mr.
section
Chaudhary, I have
97.
not understood 97.
97, Lordship. May I read 97?
Yes, please.
Appeal from final decree where no appeal from preliminary decree.
In that case, he shall be precluded from disputing its correctness in any appeal,
Lordship.
which may be preferred from the final decree.
Lordship.
But you are saying that
My appeal is against preliminary decree.
against the preliminary decree.
Yes, Lordship. If preliminary decree goes, Lordship, final decree will automatically go, Lordship. Final decree is dependent upon preliminary decree. By preliminary decree, shares, right title interest over the shares are already declared.
So basically question 1, 2 and 3.
Yes, Lordship.
No, not, yes, 1, 3 and 4.
Yes, Lordship. 5 is also required as because Lordship, first appellate court is duty bound to decide all the
That
issues
is all right.
or
That
by
is
formulating a point. But that was not done. So order
determination of points.
Yes, point
But
was
even if determination of point is not done, if in substance the appellate court has,
but there was nothing, Lordship, whether we are entitled, whether she is entitled, only because deciding section 97, my appeal was dismissed, Lordship.
I think it will be 1, 2 and 4, 1, 3 and 4 is sufficient.
Lordship.
You will have all the right to argue at the time of hearing that the questions don't involve any substantial question of law.
My lord, my submission is that lordship is not hearing at this stage, my lord. But my point is that the appeal
No, it's not about me not hearing. Under the CPC, where do you have the right to be heard at the time of formulating the questions? You show me you have a right.
My lord,
Section 105, the appeal shall be heard on the question so formulated, and the respondent shall, at the hearing of the appeal, be allowed to argue that the case does not involve such question. So at which stage? At the stage of hearing, not today.
my lord, at least, my lord, I should assist this honorable court, and therefore I want to make some submission.
I find that there are some substance.
My lord, absolutely wholly, my lord.
Your argument will be that 97 bar.
97 as well as, my lord, the principle they have, the proposition made in point number 1, that is also based on false statement.
One,
the brothers,
I am not one, yes.
Brothers are not surviving. Here the principles of Mohammedan law says that
brothers are not surviving.
Surviving. So when brothers are not surviving,
where
the
from?
only legal heir, my lord.
Where do you show the brothers are not surviving?
Yes, my lord, in my plea, and they have also accepted that.
No, in the judgment?
That is admitted, Lordship.
My lord.
She stated that in the year 1976, my father died. At the time of death, Lordship, plaintiff along with 4 brothers.
No, subsequently the brothers have died.
Yes,
Yes,
Lordship.
my lord. They are claiming
during the pendency.
No, Lordship.
Long before, my lord.
Before the
Long
filing
before.
Yes.
Before filing the suit, my lord.
But
Long
Lordship,
before filing the suit, my lord.
No, if the brothers are not surviving, then Ms. Chaudhary.
No, Lordship. If Sahib Ali Sheikh died, his property will go to the legal heirs after his death, Lordship.
My lord, the point is, my lord, there was no
Mr.
partition.
Counsel, is there any finding evidence that after the death of the brothers, there are legal heirs? Anything is there? Who are their legal heirs? Anything on record?
Yes, Lordship. She admitted in her plaint also.
Where?
That Sahib Ali Sheikh expired para 3, Lordship.
Para 3 page?
Page 8, Lordship.
Since deceased.
Yes, Lordship.
Sahib
Sahib Ali Sheikh expired long back in the year 1976, leaving behind 1 daughter and 4 sons as his legal heirs.
So the legal heirs are there.
My lord, they have died, my lord.
The legal heirs?
My lord, their claim is
No,
legal heir, my lord, only legal
heirs of Sahib Ali.
Lordship, last
My
2
lord,
lines. Your
my
Who
Lordship,
have been impleaded as the defendants.
My lord.
Lordship.
My lord, the
So
other.
these defendants are you.
Yes, Lordship.
You
We
are
are
the
from
legal
the
heirs.
legal heirs from our deceased fathers. We are the legal heirs,
My lord.
Lordship. Last
My-
line, your Lordship, kindly see. And
Yes.
Manu Sheikh, since deceased, to inherit the entire landed property.
Which line?
Para 3, Lordship. Continuous.
Yes, I've seen that. To
My
inherit the entire landed property being his legal heir.
Yes,
My lord.
Lordship. So,
My
Lordship, in the year 1976, no partition suit was filed. Had it been
My
the
lord,
case that it was filed in the year
their
1976?
claim is that, my lord, the suit was partitioned. The land was partitioned during the lifetime of the original Pattadar, my lord, owner. During the time of grandfather. The Sahib Ali Sheikh while surviving at that time there was a partition. That is a false plea they have taken, my lord. That is not correct. And
All right, Mr. Counsel, I have also heard you now. Heard MS R. Chaudhary, Learned Counsel for the appellant. Stop. Also heard Mr. A.R. Sikdar, Learned Counsel for the sole respondent. Sole respondent?
no, my lord, yes, sole respondent.
No, some other respondents are there.
My lord,
He is
here in this case, my lord, there
You
are
are appearing for which
the
respondent?
plaintiffs, the appellants are from one brothers.
Mr.
And all-
Counsel, please answer to the query of the court. You're representing for which respondent?
I am the sole respondent, Daliman Nessa.
No, there are so many respondents.
2 to 12, Lordship, notice 2.
No, my lord. Yes, my lord, only Daliman Nessa.
Respondent number 1.
Yes, my lord, the other respondents, they are the sworn daughters of other brothers.
Respondent number
And
1.
they are opposing the plaintiff.
R1, huh? Respondent number
They are
1.
opposing the appellant, my
So,
lord.
caveator. So, caveator. Eta caveat thakibo, caveator discharge kori dibo.
It was on
The
earlier-
appeal stands admitted on the following questions of law. Page 4 at Paba. 1, 3, and 4. Okay? 1, 3, and 4. Mr. A.R. Sikdar accepts notice on behalf of respondent number 1. Hence, no formal notice. Extra copies within a period of 1 week from today. Steps by registered post AD in respect of respondent numbers 2 to 12 within the period of 1 week from today. Case records from the Court of Civil Judge Bongaigaon.
Yes, Lordship.
Correct?
And Lordship, title suit P within bracket P number 31/2014 from Civil Judge Bongaigaon.
From Civil Judge Bongaigaon.
And
List,
title appeal from District Judge Bongaigaon.
list after
Is it
so and
page
so on
one,
the
it
date to
is
be
written,
fixed by the registrar. Page?
Page 1 it is written.
Page 1.
Yes, Lordship.
Right.
And Lordship, there is an IA 2441 regarding stay, Lordship, already execution.
Later. Yes.
Lordship may kindly issue notice in this.
Notice in the stay also. I also.
Oblige.
Yes. Service completed?
The service is completed. In fact, for some confusion, the matter has been listed today. Kindly see the office to date 28/8.
Yes.
28/8. In fact, there is a delay continuation petition. In that petition, the court has allowed the substitution. Now, the substitution petitions.
Where is the order where the substitution has been allowed?
Yes, 31/7. In
No,
IA.
it shows that as no order was passed in abatement and substitution application I.
Yes, ma'am.
But this is already done according to
Yes,
you.
ma'am.
Where? Which order?
In IA 1415.
1415.
1.
15. 1415 or?
Yes, 1415. There are two applications for delay continuation. It is 31/7 order dated.
They shall be substituted in place of the deceased. So it's already done.
My lord, in view of the aforesaid order, my lord, this two substitution petition that may be closed.
So those are IA 1416 and 1740.
Yes, ma'am.
But substitution of. Okay.
In IA 1416, we wanted to substitute the two sons. In IA
1416 likha. You are Mr. P. Hajorika.
Yes.
Learned, heard Mr. P. Hajorika, Learned Counsel for the applicant, and MS VV Thanu.
Your Lordship, M. Zomampui.
And Jomampui.
Yes, sir.
You are from Mizoram.
Yes, Your Lordship.
And Jomampui, Learned Counsel for the opposite party. Stop. It appears that the substitution of the legal heirs of late Dina Nath Borwa, I, the respondent number 1, which is sought in the present application, has already been allowed by this court by order dated 31/7/2023 in IA Civil 1415 of 2023. Stop. Accordingly, the instant IA stands infractious and disposed of. Next item.
Next 17140. And there is a delay continuation petition that is 1739.
Here there is a delay continuation.
My lord.
That delay is not
No,
condoned.
that in the delay continuation petition, the substitution is allowed.
1415 tar lago.
1739.
Same hobo.
Same.
It will hobo order dated.
Same order, same date.
But everything still remains same. Kali Tumar substitution to allow Korisla by order dated same 31/7/2023 in IA 1739 of 2023. Okay.
In the main appeal,
both IAs disposed. Eduta IA dispose of to decry diboyat. Lekha nai. Yes, in the main.
Well, registering you directed to correct the hospital record.
You submit that in view of the orders passed in IA 1415 of 2023 and which is the other IA 1739 of 2023, let amended cause title be submitted by the appellant before the registry to do the needful. You submit it. List after 3 weeks on a date to be fixed by the registry. I need to dispose parameter 141. None appears for the appellant when the matter is called. List after 4 weeks on a date to be fixed by the registry. 3-4 served.
Yes, my lord. The advocate appeared, my lord. So, my lord, this 1007 for condonation of delay may be considered, my lord.
1 second. What about the substitution?
Yes, my lord. 3, 4, and 16. But my lord, in the meantime,
3, 4, and 12.
My lord, 1007, my lord. MC 1007.
I can't hear you.
1007 is the delay.
1007
MC.
This is a delay condonation.
Delay condonation. 336 days was there, my lord, not within the knowledge of the petitioners, my lord. 336 days, my lord. And my lord, what happened, my lord, in the meantime?
Is service completed?
Service completed, my lord, because my lord, in other respondents, my lord, who did not contest the main suit and the amendment petition, by the order of this honorable court, they have been deleted, my lord, struck off, my lord. So, my lord, and in the meantime, the
no, but you see, here from the office note, it appears there is an order on 2/6/22 office note, which says no application for striking out the names of respondent 3, 4, 6, 7, 8, 11, 12, 14, 15, 16 has yet been received.
Yes, but subsequently, I have filed IA 2264 and 1173. Those are disposed of, my lord, by struck off.
1 second. IA
2264 of
2264
of 22.
22 and
my lord, IA 1173 of 22.
1173.
Yes, my lord.
Of 22.
23, my lord.
23.
Yes, my lord. By these IAs, my lord, the respondents have been struck off, my lord.
Struck off. Arun, the other one. So remaining, who is there?
Remaining, my lord, this don't appeared, my lord.
No,
the advocates appeared 1, 2, 3, 4,
2263.
5, and 6, my lord.
1173.
One, 2, 3, 4, 5.
Yes. Now, who are left? Who are left after this?
In the miscase, my lord.
Yes.
In the miscase, my lord, 1, 2, 3, 4, and 5, my lord.
1,
1, 2, 3,
2,
4, and 5.
3, 4, and 5. Now, whether service is completed amongst the
Yes, my
against
lord.
these 5 respondents?
The advocate's, my lord, name is appeared, my lord, in the cause list, my lord.
He's appearing for all the 5 respondents?
Yes, my lord.
Rupak side of him.
In the cause list, my lord, mentioned.
Wakalatnama ko. Oh, 1 and 2 আছে. Then 5 আছে. One, 2. One, 2, and 5 I can see. Wakalatnama is there.
Yeah, 2 sets of Wakalatnama, my lord.
Yes. But that is for respondent 5, 9, 10, and 13. And 1, 2. 4 is 4 has been struck off, right?
No, my lord. 4, my lord.
4 is still there.
Yes, my lord. And for 4, my lord.
It will be
Substitution is for 4, 3, 4.
Substitution is for
3, 4, and 16.
3, 4, and 16.
But my lord, 16, the only legal heir in the meantime expired, my lord.
Now, what is the grounds of delay?
Ground, my lord, that was not within the knowledge, my lord.
Where have you stated?
Paragraph number 6, page number 9, my lord.
In 1007, right?
1007.
Paragraph number
6, page number 9. And it is only after return of the notice.
Paragraph
number 6, page number 9. It is only after return of the notice, my lord, the petitioners came to know that they are expired.
Okay. Please take it. This is MC 1007 of 2015. Okay. Heard Mr. MJ Kadir, learned counsel for the
petitioners.
Applicant.
Applicants.
Stop. None appears for the respondent. Numbers 1, 2, and 5. Despite notice having been served and wakalatnama having been filed by learned counsel. Stop. Further, it appears that the names of respondent numbers 6, numbers 9, 10, 12, and 13 original in the CRP has been struck off by this court by order dated 10/5/2023 in I 1173 of 2023, and the names of respondent numbers 6, 7, 8, 11, 14, 15, 16, 17, 18, 19, and 20 is also struck off by order dated 14/11/22 of this court in IA 2264 of 2022. This application is filed for condoning the delay of 336 days in filing an application under Order 22, Rule 9(2) of the CPC for an order of setting aside abatement.
Yes, ma'am.
Stop. Mr. Kadir, learned counsel for the applicant, submits that due to want of knowledge, the aforesaid delay has occurred, which is beyond the control of the applicant and unintentional, and therefore the aforesaid delay warrants to be condoned by this honorable court. Stop. I have given my prudent consideration to the arguments made by the learned counsel for the applicant and also peruse the grounds of delay averred in the condonation application. Stop. Paragraph 6 of the aforesaid of the miscellaneous application is reproduced hereunder for ready reference. Page 9, A to A. Apparent that because of want of knowledge, about the death of the respondents, comma, the delay had occurred.
Yes.
Stop. The aforesaid explanation appears to be sufficient and bona fide. Delay condoned. Registry to register.
My lord, already CRP is registered, my lord.
Right.
Next, my lord,
Disposed of.
Yes, 1009 may be, my lord, taken off, my lord. Setting aside abatement. 1009 may be taken.
Which one?
1009, my lord, MC. It is for setting aside abatement.
This will take it on another date. It will the list after a week on a date to be fixed by the registry.
All right.
MC 1009 of 2015. It is disposed of. Disposed of this case number 1007. All right. Date to me.
Oblige.
Yeah, he's a Bhargav.
That'd be item 8.
None appears for the petitioner when called. List after 2 weeks on a date to be fixed by the registry.
Item number 23.
Ma'am, please, Your Lordship.
Yes.
Your Lordship, in this case, Your Lordship, if Your Lordship would place order dated 22/2/23, Your Lordship, this case was placed before the Lavajima Court, Your Lordship, for service of notice upon respondent number 3 to 6, Your Lordship.
Yes.
And we are allowed to take file substitution for respondent number 2, Your Lordship. Thereafter, we have taken step, and as per office note dated 12/9/23, service report are complete upon respondent number 3 to 6, Your Lordship. And for respondent number 2, Your Lordship, we have filed an substitution, Your Lordship, and that is under defective. Because of, Your Lordship, there are some minor.
So you cleared the defect?
Yes, Your Lordship, we can clear the defect after the order of this honorable court. If this honorable court would direct the registry, because while filing that main appeal, Your Lordship, RSA, there, Your Lordship, they have in the filing section, they have done some mistake, Your Lordship, that respondent number 2 was given in place of respondent number 3. And at present, Your Lordship, SRO is not there, and I require that file, Your Lordship, to go through that discrepancies, Your Lordship.
Your name?
S. Paul, Your Lordship.
Mr. S. Paul, learned counsel for the appellant, submits that there has been some defect as regards the
I-8 12080 of 23.
I-1 2080 of 2023.
For substitution of respondent
File
number 2.
for substitution of respondent number 2.
2, Your Lordship.
2.
Yes, expired substitution.
Why don't you withdraw that and file a new one?
No, Your Lordship. Actually, actually, what has happened, Your Lordship, the filing section, Your Lordship,
they have made some mistake while uploading the name of respondent number 2 and 3. Thereafter, when we have filed that substitution petition, Your Lordship, the computer is not accepting that, Your Lordship, because the respondent number 2
Let
is
the
different.
defects be rectified within a period of 1 week from today.
And Your Lordship, one more small prayer, Your Lordship, can the matter be listed after 10 days? Your Lordship, senior SRO is in
Clear your
Chennai.
defects. Next.
Okay.
Lordship, I'm from respondent number 1.
Oblige, Your Lordship.
Item number 24.
May I please, Your Lordship. Lordship will find office note dated 27/8/24.
Service completed, Mr.
No, my
Sharma.
lord. 6/8, no, my lord. 6/8,
Await
9,
service in respect of respondent numbers
6, 8, 9,
6,
and
8, 9, and 10.
no, my lord. I may be allowed to take face test because addressee left, my lord. So
In the meantime, Mr. R. Sharma, learned counsel for the appellant, is allowed to take fresh steps in respect of the
Respondent
aforesaid
numbers
respondents.
6, 8, 9, and 10,
Aforesaid respondents
my lord.
by
By collecting correct address.
by collecting correct address. List after 3 weeks on a date to be fixed by the registrar.
I'm appearing for respondent number 1, 2, and 3.
My lord, I will take steps in the, my lord, condonation of delay petitions. 2 condonation of delay petitions. is there.
Wherever the order is, yes.
Oblige.
May I have a Lordship? Lordship,
Yes.
senior is appearing on court number 40, Lordship.
For order matters, why you need your senior? Why is this matter for order today?
Lordship, there is 2 IA, Lordship. One for substitution of legal heirs of respondent number 8, Lordship. That is IA number 96721. And one is for state of
The IA 2860 is for substitution.
2860 for state operation of the learned judgment and decree of the learned.
Yes, Lordship, I'm appearing for respondent 127, 9211, and 12. Lordship, in the substitution petition, the names of the legal heirs of respondent number 8 has been wrongly reflected. So it has not been corrected yet, and we have supplied the corrected.
Can you
names to
make the
them.
corrections first?
Yeah.
Your name?
R. Borwa.
Mr. R. Borwa, learned counsel for respondent number?
Respondent number 127.
For respondent number 127
9 to 11.
and 9 to 11.
And a respondent 12.1 to 12.5.
And 12.1 to 12.5
Yes, sir.
submits that the name of the
Legal heirs of respondent
legal
number
heirs
8.
of respondent number
8
is wrongly
reflected
in the cost title.
Cost item.
Stop. Mr. So and so seeks time to obtain instruction in this regard and do the needful. Yes, you do the needful in the meantime. List after 2 weeks on a date to be fixed by the registry.
Oblige, Lordship.
Item 26.
May I please, Your Lordship? Lordship, in this matter, Lordship, the appellant has expired, Lordship.
This is the matter you were mentioning.
Yes, Lordship.
Expired.
Yes, Lordship.
Yes.
9/5/23, na?
Yeah.
9/5.
Lordship, we are processing on
9/5.
substitution petition, processing or filing of substitution petition, Lordship. Now kindly give us time.
Your name?
Yes, and Kolita, Lordship. On behalf of these orders.
MSN Kalita, learned counsel for the appellant, submits that during pendency of the regular second appeal, the appellant has expired and
on
accordingly
9/5/23.
seeks time to
9/5/23.
and accordingly seeks time to file necessary application in this regard. You are saying something?
No, nothing.
Prayer allowed. List after 2 weeks.
Yes.
On a date to be fixed by the registry.
Obliged.
27.
May it please, Your Lordship.
Yes.
In this case, Lordship, we have filed the service affidavit. But registries, as per office note, that affidavit stated to be filed by the petitioner's counsel on 25/4/2022 could not be traced out.
Yes, Mr. Chaudhary, you are appearing for?
Respondent number 1, my lord.
And?
8.
1 and 8. 2 and 3, addressee not located in the address.
Yes, Lordship, we have taken Dusty service 2 to 9.
You have taken?
Yes, Lordship.
Could not be traced.
No, Lordship, they have received Dusty affidavit, Lordship.
No.
At the stage
Here,
of service.
the office note says the affidavit stated to be filed by the petitioner's counsel could not be traced.
Yes, Lordship. But we have filed on 25/4/2022.
It is reflected, but the office doesn't seem to have. Why don't you file another affidavit and sort out the controversy?
Lordship. Or I will call
File.
my advocate.
There's no. See, there is no point of
Lordship.
wasting time. It appears
Original receipt copy we have submitted along with
along that you otherwise you file another set and finish the controversy. It is only an affidavit of service, Ms.
Today only we
Chaudhary.
came to know that there was no trace
A office note dated 21/11/22 indicates that the affidavit of service to be stated to have been filed by the petitioner on 25/4/22 could not be traced out by referring the computer software. Stop. Have you all received this affidavit of service?
Yes, my lord.
You have received?
I have received it.
However, Mr. N. Chaudhary, learned appearing for respondent number 1, and Mr.
AF Anumul.
AF
Anumul.
Anumula, learned counsel, appearing for respondent number 8, fairly submits that the copy of the aforesaid affidavit of service has been received by them. That being so, let a photocopy of the aforesaid refile.
Sir, I will check with my clerk, Lordship, whether it is there is any defect in this affidavit, Lordship.
Could be.
Maybe that
MS Chaudhary, learned counsel for the petitioner is for the appellant, right? For the appellant is allowed to refile the affidavit of service and or take instruction in the matter.
Lordship. I'm for the petitioner,
And do the
Lordship.
needful.
This is a CRP IO, Lordship. I'm appearing for the petitioner.
Petitioner, appellant, no, right?
Obliged.
After 2 weeks on a date to be fixed by the registrar.
Lordship. Interim assembly.
28.
Yes. Service completed?
Yes, Lordship. It was already in the hearing column, Lordship. So I made a mention for fixing
Yes,
a date
list
for
the
hearing.
appeal for hearing.
Lordship.
I'll fix it for hearing. It appears that this matter has been wrongly listed today under the order column. Stop. Let registry, let the appeal be listed for hearing as directed earlier by this court by order dated 22/3/2024.
Lordship may fix a date.
You have seen the last judicial order, Ms. Chaudhary.
Lordship. Obliged.
You can always file an application for early hearing because it says due course. Now I cannot change that.
After that, Lordship, it came in the hearing
Yes,
column.
but you see it says due course and it has not come for hearing.
Lordship.
So
Obliged.
let registry do.
Lordship,
Yes.
service is complete as per
Service
last order.
complete. LCR ahisi
Notice was
Yes, sir.
issued to the respondent number 2, and as per office
I'll
notice
fix it for hearing.
28 to 2024.
You are
notice was duly
appearing
served.
for
Respondent number 1, Lordship.
1 and 2 AD card
Only one and
received
two.
back.
One is insurance, 2 is the owner come
And received back.
driver.
Office note dated 28/8/24 indicates that service in respect of respondent number 2 is complete. Stop.
LCR.
Mr. Your name?
SP Sharma, Lordship.
Mr. SP Sharma, learned counsel, enters appearance for respondent number 1. As such, service stands complete. Stands complete. It appears that the case records has already been received from the tribunal, from the MACT, jurisdictional MACT. Stop. List the matter for hearing on in the usual course.
Obliged.
Service completed.
Yes, service so far completed.
Delay condemnation is there. Substitution petition, there is a delay of
1,639 days.
Yes, my lord. I'm paying for customer for time being, my lord.
Huh?
I'm paying for time being, my lord.
Time being? Why?
F2, my lord.
Why?
My senior will appear in this case.
It's a delay condonation. While you are good enough,
My lord.
you are good enough. What are the grounds for delay?
My lord.
So all respondents have.
There is two respondents only.
So you both are appearing for the respondents?
Yes, my lord.
Okay, fine. Yes, what is the ground?
My lord, in my petition paragraph 2, I have stated the ground.
Illiterate person, rustic background. That is the ground.
Yes, my lord. Page 4, paragraph 2, may I read, my lord?
Yes, read.
During the pendency of the said regular second appeal, number 167, my lord, there is some typographical mistake, my lord. 2023, instead of 2023, it will be 2010, my lord.
Okay.
RSA number 167, 2010, my lord.
Yes.
The sole appellant, namely Fazur Ali, died on 1/6/2018. The applicants are the permanent resident of village Rampur under Kolgasia Revenue Circle in the district of Borbeda. The applicants are residing in a remote area, as mentioned above. The father of the applicants was an illiterate person, and before his death, he was suffering from serious illness caused by the asthma, along with other old age disease. And in resulting of that, he was in a deathbed condition almost 2 years. From that period of time, there was communicational gap between the appellant and his earlier engaged counsel. At that time, we are not the engaged counsel.
All right, you read.
Later on, after death of the sole appellant, the applicants could not able to cooperate with their engaged counsel in time. Thereafter, COVID-19 pandemic situation breakout from the year of 2020 and paralyzed the, my lord.
Okay, okay. Read. Read.
And paralyzed the function of the court almost 2 years. In the year of 2022, the legal heirs of the sole appellant started communicate with the engaged counsel, and they decided to engage the present sets of counsels in the month of February 2023, my lord. Thereafter, they came to know about the current status of their case. I have annexed here with on the death proof certificate issued by the local Gavura, my lord.
So basic ground is want of knowledge about the death.
Yes, my lord.
This is the ground. Any objection?
No. I have filed objection. Otherwise, for a legal ends of justice, my lord.
Yes. Shall I condone or I will wait for your senior to come now?
My lord, I am paying for condone, my lord.
No, I'm saying I'm ready to condone. You want
Yes.
You want this order in your presence, or you want me to pass this order when your senior come?
Order pass me in my.
Your name?
A.K. Azad, my lord.
Heard Mr. A.K. Ajat, learned counsel for the applicant. Stop. Also heard Mr.
H. Das.
H. Das, learned counsel for respondent.
Respondents.
Respondents. For the respondents. Stop. This is an application under Section 5 of the Limitation Act 1963 for condonation of delay of 1639 days in filing the substitution petition. In filing the accompanying substitution petition. Stop. Mr. A.K. Ajat, learned counsel for the applicant, submits that due to want of knowledge of the respondent, the delay had occurred in filing the accompanying substitution petition, and as such seeks condonation of the same. Stop. Heard, perused. Paragraph 2 and 3 of
Yes.
Paragraph 2 and 3 of the aforesaid condonation interlocutory application is reproduced hereunder for ready reference. After that, apparent that it is due to want of knowledge about the death of the respondent, the delay of 1639 days have occurred in filing the accompanying substitution application.
Date of respondent, not appellant.
Appellant, the respondent is a date of appellant. Accordingly, the delay is condoned. Let registry number and register the accompanying substitution application. Tar agot likhi dibo. Their submission to episode I forgot. Mr. H. Das. Yes, your submission.
Regarding this, I have stated not sufficiently explained.
Mr. H. Das submits on the other hand submits that the applicant has not explained the delay sufficiently.
Yes.
And therefore warrants no condonation from this honorable.
There is another IA for setting aside abatement.
It is disposed of there. This is 883. Yes. Yes. Which one? I 884.
IA 885 for setting aside abatement, my lord. 884 for substitution.
For abatement.
Yes, my lord.
Mr. Das?
Yes, my lord. I have not received the any your lordship may dispose of.
No, for setting aside the abatement.
Yes, my lord. And my lord, possibly my lord, substitution of the legal years. Substitution of legal years, it is in my lord 884. And my lord
885 is the setting aside amendment.
Yes.
885 icon?
Yes, my lord. Both.
Or 884 as any get.
Yes.
885 is my lord for my lord
for setting aside the abatement.
abatement.
Yes.
And 884 is my lord substitution of the legal year.
Okay. First in 884, 885. Heard. This is an application under Order 22, Rule 9 of CPC for setting aside the abatement of RSA number 167 of 2010. Paragraph 2 and 3 of the aforesaid application is reproduced hereunder for ready reference. Apparent that appropriate legal rights of the applicants is to be decided in RSA number 167 of 2010, and therefore the prayer sought for abatement appears to be bona fide, allowed. Accordingly, the instant application is allowed, and the order dated, which is the order of the abatement which has to be set aside?
My lord. Abatement in this sense, my lord, after the date. That period, my lord, after 60 days, 90 days, that was the period. 90 days.
So what is the order, the effective order, what is to be given?
No, my lord. In view of the disposal of the condonation of delay, the legal heirs of the appellant has to be substituted, and thereafter, in view after my lord, in view of the substitution of the legal heirs, abatement, setting aside abatement, that also may be.
So 1-8, the other one also has to be
in view of the
in view of the order passed in IA 883 of 2000. IA 883 of 2023.
Yes.
Whereby the delay for substitution has been condoned. The instant application stands allowed. That is enough.
Yes, and registry, he has to supply the copy for substituting the legal heirs.
That I have given, I think, in the somewhere. Let a copy of the amended cost title be submitted before the registry.
Yes, madam. 17 numbers of family members.
For doing the needful by the registry.
17 numbers, my lord.
And 883 is 883 to hoye gol 884. 884 it has
884.
884, my lord.
Paragraph 5, their substitution.
Yeah, paragraph 5.
It will be 5.
Yes, 5.
In the front to port.
Legal, yes, I had mentioned.
Application under Order 22, Rule 3 of CPC for substitution of the legal heir of the applicant appellant in RSA number 167 of 2010. In view of the order passed in IA 883 of 2023, condoning the delay,
yes,
the instant application for substitution stands allowed.
Yes, ma'am.
3.
Yes. Case, my lord, service is completed.
Service complete, Mr. Bacha.
Yes, my lord.
You are appearing for all the respondents.
Yes,
So this appeal can be fixed for hearing. Yes. Heard Mr. A.K. Hussain, learned counsel for the appellant. Stop. Also heard Mr. A. Batra, learned counsel for the respondents. It appears that the case records has been received from the trial court. Let the matter be listed for hearing in the due course. Yes, what is this review petition?
Lordship, pursuant to the last order, Lordship, we had taken steps, Your Lordship. Now informed this morning that they are
Lordship, we have filed our wakalatnama today.
You will be appearing for the sole respondent?
There are two,
Respondent
Your Lordship.
number 1 and 2.
For
both the
All
respondents.
right. MS?
D. Devi.
MS D. Devi. Learned counsel enters appearance on behalf of respondent numbers 1 and 2. This is a review petition.
Review petition, Your Lordship.
So are you going to file any objection?
Objection will be filing.
And seeks 2 weeks time to file objection. Prayer allowed, list after 2 weeks on a date to be fixed by the registry.
Lordship, may kindly clarify that services completed the matter may come for admission, Your Lordship.
Their appearance to corpus of thus appearance on behalf of the respondents. The service on behalf of the respondents stands complete.
Lordship, there's an interim order, Lordship.
Interim, if any, shall continue till the next date of listing. All right, you can
May I please,
Yes.
Your Lordship? Lordship, as my senior has mentioned the item in the morning.
I have forgotten.
My lord.
Yes.
So-
What is the issue?
Lordship, because the last order, which is pending, it was passed by Honorable Justice Devasis Borwa. That's why.
This
We
is
pray
what?
for
This is the
adjournment.
FAO.
Yes, Lordship.
Is this matter part heard?
Yes, my lord. Lordship.
Which order says? There's no order saying it's part heard.
Last 16-8.
16.8 order doesn't say it's part heard.
My lord, we were directed to bring on record and
Correct, but the order doesn't say it's part heard.
Yes, Lordship. Order.
Then, on what basis a submission has been made that this is a part heard matter? As prayed for, list this matter after 1 week on a date to be fixed by the registry.
Obliged. Much obliged.
Please, it's a application under order 41 rule 19 for readmission of the appeal.
For readmission of the appeal.
Yes.
My lord, it was dismissed for default. We may be permitted some time to file an objection.
You want to file an
File an
objection?
objection.
All right. Heard Mr. S. Heard Mr. Silaritya, learned counsel for the applicant. Stop. Also heard Mr. N. Chaudhary, learned counsel for the respondents. Mr. Chaudhary N. Chaudhary seeks 2 weeks time to file objection in the matter. Prayer is allowed. List after 2 weeks on a date to be fixed by the registry.
Deeply.
May I please, my lord?
Yes. Why is this matter for orders?
My lord, as per office note, my lord, the notice returned back by remarks that the
1 and 2 has not received.
no such person residing in this address, my lord.
So you will take.
I will verify and my lord take fresh steps, my lord.
Mr.
A.K. Gupta.
As prayed for by Mr. A.K. Gupta, learned counsel for the appellant, list this matter after 2 weeks on a date to be fixed by the registry to enable the learned counsel for the appellant to verify the address of the respondent numbers 1 and 2 and take fresh steps thereafter. Yes.
This matter stage has been completed and the respondent entered appearance. So,
Ms. Borwa, you are appearing for all the respondents?
All the 3 respondents, sir. Fixed for admission hearing. Your
This
Honor.
is a CRP.
Yes, sir.
So,
CRP.
in view of the appearance of MS Borwa, R. Borwa, learned counsel, appearing for all the respondents, service stands complete. list this matter for admission.
No, no, date may be fixed. My humble
Yes,
opinion.
yes, admission, right?
Admission,
Yes,
Your Honor.
yes, Lordship.
List this case for list the matter for admission on such and such date.
Your Honor, 19 September, if possible.
Lordship, the LCR may be called for.
LCR will not be required, Your Honor, because all the documents have been annexed. It's a CRPIO, Your Honor.
All right, on the next date. The SK Learned Counsel
My lord.
for the appellant, stop. None appears for the respondent. This application is filed under Order 22, Rule 3 of CPC, seeking substitution of the legal heirs of the appellant number 1.
Along with, my lord, delay petition also.
Stop. There is a delay for what?
My lord, for filing the substitution.
This one.
Yes, my lord.
Where is the delay?
My lord, number 2476 is the delay petition, my lord. 2476. My lord.
So then first notice will go in the condonation.
Yes, my lord.
A order to IA 2476 of Mara. IA 2476 of 2024. This is a delay. This is an application seeking condonation of delay for filing the substitution
My lord.
application. Issue notice returnable 2 weeks. Steps by. They've already entered appearance.
Already they are appearance. We have served the copies also, my lord, of the IS.
But nobody is appeared.
They may file objection, my lord, if
Steps
today,
by registered post AD
my lord.
within a period of 1 week from today.
My lord.
List after
Obliged.
so and so accordingly. Yes. Change को बोला ही नहीं. Yes, Mrs. Awala.
Lordship, there are cross appeals by either side. Perhaps my
AD card has not been received back. R1.
Yes, Lordship. Actually, I am appearing for the respondent number 1, Lordship, because the
So
next
then
item.
I can say the service R1 is complete.
Yes, I'll file the Wakalatnama, Lordship, as respondent number 1, because the next item is by us as a appellant, Lordship. Item number 46. Okay.
In item
46.
first item 45, Mr.
T. Kolita.
Mr. D. Kalita Learned T. Kalita Learned Counsel Learned Counsel enters appearance on behalf of the
Respondent number 1.
respondent number on behalf of the sole respondent. Stop. In view of the above, service in respect of the respondent stands completed.
Lordship, I may be allowed
LCR has come.
Lordship, I may be allowed to file the Wakalatnama in this case.
So why do you need any order from this court for filing wakalatnama? You file.
Okay, Lordship, we'll file.
Has Mr. T. Kalita, Learned Counsel for the respondent, submits that he has received instructions to enter appearance on behalf of the sole respondent. Stop. He stops and in view of the aforesaid endorsement made by the Learned Counsel for the respondent, service in respect of respondent number 1 stands complete. In the meantime, he may file his wakalatnama in accordance with law. Stop. Further, it appears that the case records has been received from the MACT, from the jurisdictional MACT. Stop. List the case for hearing in the due course.
My lord, in item 46, I am appearing for respondent number 9.
And in item 46, this is in 45, okay? 46, huh? 46, all respondents complete.
Lordship, as per office note, Lordship 29/8/2024.
5 and 6.
5 and 6, addressee not found.
This is also from the same case record.
Same judgment, Lordship.
Basically, Your Honor, the fight is between the principal respondent and
Office note dated 29/8/2024 indicates that unserved notice has been received back from has been unserved notice in respect of respondent number 5 and 6 has been received back with postal remark within quotes address not found. Stop. You take fresh step.
Lordship.
Mr. T. Kolita, learned counsel for the appellant, seeks 2 weeks' time to take fresh steps in the correct address in respect of respondent number 5 and 6. Prayer is allowed. List after time decide due course list after 4 weeks. List after 4 weeks. The other one, the due course list for hearing. After 4 week period.
Deeply obliged.
Lordship, the legal years of sole appellant filed 3 petitions: condonation, abatement, and substitution. Let us hear the
Which is the condonation?
Condonation to 1860.
1860.
662 days delay.
662 days.
Delays. Initially, the appellant's advocate died. Thereafter, a sole appellant expired on 13/1/2020. Then thereafter, COVID
Initially,
started.
who died?
Initially, appellant's advocate died.
Appellant's advocate died.
Lordship.
And then?
Then sole appellant died.
He also died.
He died on 13/1/2020. Thereafter, COVID started. So we have explained that period.
Paragraph?
Paragraph we have given of that, including death certificate, that paragraph 3 on 1.
Paragraph?
3. Applicant begged to state that the said in substitute petition could not be filed within the period of limitation. As such, the connected application for setting aside abatement has been filed with a delay of 662 days. For condonation of delay has been explaining the grounds of delay. Pankaj Kumar died dealing with him. He was sole appellant. He was dealing with the matter. Thereafter, COVID started. 5.
Any objection?
My lord, I have filed an objection.
Yes. Any serious objection?
My lord.
Yes, because it appears that there were reasons.
My lord, actually there is a delay of 998
No, but we'll
days.
go by what registry
Office,
has.
yes,
The office has recorded.
My lord,
Sufficient.
their contention-
Generally, in the condonation application that this court has been faced with, all the explanation appears to have been explained in one paragraph. This is a case where more than 6-7 paragraphs.
That is there, my lord, that is there.
And there appears no reason for this court to doubt the averment. I've read it.
My lord,
The advocate died.
all the legal
appellant
errors are
died.
major, my lord. All the legal errors are major. And why they are sleeping, my lord, for last 998 days? Although
They were not
661.
aware. They came to.
They are the sons, my lord. They are the sons of wife.
All right.
I like to, in that case, I like to hear the matter. In case he has any objection, I like to go through it.
Yeah, it's all right. I'm allowing it. Do you have a problem if I allow the condonation?
Yes, Lordship, certainly we will be happy. We will be happy.
Heard MS heard Mr. P.S. Deka?
BK Bhagavati.
Huh?
BK Bhagavati.
Heard Mr. B.K. Bhagavati, learned counsel for the applicant. Stop. Also heard Mr. P.C. Day, learned counsel for the respondents.
All the respondents.
Stop. This is an application under Section 5 of the Limitation Act 1963, seeking condonation of delay of 662 days in filing the accompanying setting aside abatement petition. Stop. it appears that the appellant
Appeal number 1.
Preferred regular second appeal before this court challenging the judgment dated 23/12/2015 and decree dated 6/1/2016 passed in title appeal number 6 of 2015 affirming the judgment and decree dated 23/2/2015 passed by civil judge in title suit number 57 of 2010. Civil Judge Nagaon. It further appears that during the pendency of the said second appeal, the sole appellant expired on 13/1/2020, leaving behind the present applicants as legal heir and successors. Stop. However, the accompanying substitution application could not be filed within the period of limitation for reasons beyond the control of the applicants. Stop. Accordingly, a delay of 661 days occurred in filing the accompanying substitution application. Stop. Mr. B.K. Vagavati, learned counsel for the applicant, submits that initially, because of the death of the appellant's lawyer, the
Mr. G.C. Fukon.
Huh?
Mr. G.C. Fukon.
Mr. T.C. Fukon, and subsequently for the death of the sole appellant, there occurred delay in filing the accompanying substitution application. Stop. Mr. P.C. Day, on the other, learned counsel for the respondent, on the other hand, submits that no sufficient explanation has been given for the aforesaid delay of 661 days in filing the accompanying substitution application, and therefore the delay ought not to be condoned. Stop. I have given my prudent consideration to the arguments made by the learned counsel for the parties and perused the grounds for delay averred in the condonation application. Stop. Paragraph
6, 7, 8. There are annexures also.
Paragraph 4 to paragraph 14 is reproduced hereunder for ready reference from page 4 to 9. There. Apparent from the above that the explanation adduced by the applicant in the instant interlocutory application appears to be sufficient and bona fide. Stop. Accordingly, the delay of so and so days in filing the accompanying substitution application stands condoned, allowed.
Lordship, he has filed the application. Setting aside abatement, in that case, all the 3 applications will come.
Yes, give me one by one.
Oh, Lordship, numbers.
It will,
1858.
1 second, 1860, we're going to dispose of. Then, which is the next one?
1858.
1858. What is 1858?
Setting aside abatement.
It is for setting aside abatement. Okay. Same parties and application. Okay, but this is an application under Order 22, Rule 9 of CPC 19.8, seeking setting aside abatement. Then, in view of the order passed in IA so and so 1860 of 2024, these instant application stands allowed. Stands allowed.
Substitution 1859.
Given the next 1859. 1859. This is an application for substituting the legal heirs of the applicant. Stop. applicant has made, in view of the order passed in IA Hetu Didiba, this instant application of substitution stands allowed. Let amended cost title be submitted before the registry for doing the needful. Disposed of. Yes.
I have filed an application.
Yes.
2651.
What is that?
2561, my lord.
What is that?
That is for injunction, my lord. My lord, during the pendency of the 2nd April, my lord, the
This will take it up on another date.
appellants are going on construction.
Very well, on another date.
My lord,
They have been just substituted.
They are constructing the house.
No,
So,
another
my lord,
date. When do you want it?
Monday, next Monday, my lord.
Not Monday, let them file
Otherwise, my lord, they are
Mr. Counsel, the amended cost titles has to be filed.
as well as we may file objection also.
You do whatever you want to do. List this matter next week, no, after the date, after 1 week, on such and such a date.
Date may be given, my lord. Kindly, my lord. Date may be given.
I'm giving a date.
Yeah?
16th September. Bhargav. Appeal to IA to logo deliver. IA to logo deliver.
May it please?
Yes.
Lordship, in this IA, we are praying to send back the lower court records which have been tagged with this RSA.
I'm sorry, you are seeking what?
The LCR which has been tagged with the instant
You want it
RSA.
to be sent back?
Yes, Lordship.
For
to produce evidence in the another connected title suit which is going on in the lower court, Lordship, in the trial court.
Serious objection. Serious objection. How can this play be made?
What is the other case that is pending?
That that is for eviction, Lordship, which we have filed.
And this records is relatable to which case?
This is, my lord, related to a suit that was filed by the appellant in the 2nd appeal, which was for declaration of tenancy right. Now, the suit was dismissed. The title appeal was filed, that was dismissed. Against the concurrent findings, we have come before this honorable court. This honorable court has admitted the 2nd appeal. Now, before that, my lord, there was actually, on a bona fide mistake, a revision petition filed. This honorable court gave us the liberty to withdraw the revision petition being not maintainable and to file 2nd appeal. During the stage of revision petition, initially the records of both the proceedings were called for, the suit as well as the title appeal, and that came.
Now these are not connected to the title suit 66.
No, they are only trying to contend that some of the documents would be relevant out there. Now, if a particular document is lying
how
here,
can this blanket kind of an order be passed?
and they can very well take the.
What are these documents that you want?
Lordship, the registered sale deed which we have exhibited as Exhibit A.
So the original is before this court.
Yes, Lordship. It has been tagged.
So they can, I think, Mr. Dhar, there is some provision to have this document through the registry, I think. No, when an original, in a given case where the original is part of the case records in one case, suppose in another case the same is required, then what happens? No, that is why I'm saying, but
certified copy.
no, but yes, certified.
Certified copy can be,
That is what I'm asking.
but from our registry doesn't provide certified copy from the LC.
Then how certified copy will be given from that office? Because the office will have a copy.
And my lord, this is something that I need not say, but my contention is, if they need that particular document which is out here in the form of voting, they can file a petition under Section 65 of the Evidence Act. The court of
evidence to section.
Section 65 of the Indian Evidence Act provides for secondary evidence.
Sitting in this bench, I have noticed every day is a learning. It's an endless learning. Evidence. Yes, you may take a seat. Evidence Act. I don't think
Lordship,
I
even
can
if
pass
the
any order,
origin-
but for academic reason, I'm just looking into it because it is how can the case record is a part of the title, part of this appeal which is pending here. How can we send it?
Lordship, in that case, the evidence we have to file in the another case which is
No,
pending.
there are
Lordship.
provisions. You'll have to do something else. Section.
My lord, will take up section 65. There are instances which have been laid down where, in case of original documents not being able to be produced, secondary evidence can be allowed.
Yes. You apply for certified copy. What is stopping you? I'm dismissing this application.
Lordship may fix another date. Only one date may be given. I'll take necessary instructions about the
What
secondary
instructions
evidence.
will you take?
About the secondary evidence, Lordship.
That is going to be of no help for you in this case. As far as this IA is concerned, the prayer is not maintainable. Right. You are MS Todi? Heard MS Todi, learned counsel for the applicant. Stop. Also heard Mr.
D. Chakravarti for opposite party number 1 in the IA, and I am the appellant.
D. Chakravarti, right? D. Chakravarti for the
opposite party number 1 in the
for
IA.
OP number 1 and A. Bhattacharjee for
2 and 3.
For OP 2 and 3. This is an application under section 151 CPC seeking direction for sending back the case records of title suit number 133 of 2010 and title appeal number 7 of 2022, which is tagged along with the accompanying regular second appeal, i.e. RSA number 128 of 2024. On the ground that the aforesaid case, on the ground that certain documents available in the said case records are required to be filed as evidence in affidavit in another title suit, being title suit number 66 of 2022. Stop. Yes, what are the documents? Where have you said, Mr. Todi?
Yes, Lordship. Lordship, in the main case, page number.
No, in your application, where have you said what documents you want?
In the application, we have not stated exactly what applicant documents because we were seeking for all the exhibits.
How can you do that, Ms. Todi? You are not in, you are filing an application. You do not even disclose. Some seriousness has to be shown from the bar. You cannot simply, by matter of course. Yes. MS Todi, learned counsel for the applicant, submits that the case records are necessary for preparing the evidence in affidavit in title suit number 66 of 2022. Are you all parties there?
Yes. Eviction is being sought for against me in that case.
In which eviction is sought against the OP number 1. Stop. Mr. D. Chakrabarti strongly opposes the said prayer and says that there is no provision in the Civil Procedure Code for sending the case records of a title of a suit which is pending before the appellate court for consideration of the regular first appeal,
Second appeal.
regular second appeal, on the ground that the same is required in connection with another suit. Stop. He further draws the attention of the court to Section 65 of the Indian Evidence Act 1872, which provides taking of secondary evidence relating to documents in certain cases. I've given my prudent consideration to the arguments made by both the parties and perused the averments made in the aforesaid application. Stop. In the said application. It appears, Billy Cohen, in paragraph 2, 3, 4, 5, 6, 7, 8. It appears contact till 8, huh? Thus, the ground on which the prayer for sending the case records to the trial court in respect of title suit number 66 of 2022 is sought is that in order to file the evidence by way of affidavit on the next date of listing of the said suit, the original documents which are currently tagged along with the accompanying regular second appeal before this court and forms part of the case records is required. Stop. However, it appears that no details of any documents have been provided in the interlocutory application. Be that as it may, the applicant has other applicant has other remedies available in law for bringing in evidence, documents before the trial court. Stop. In view of the above, this court finds no merit in the prayer sought in the interlocutory application, and accordingly the I stands rejected, disposed of.
Obliged, Lord.
All done? Asa?
Number 39.
Hearing. Yes.
Next legal lordship.
The hearing matter.
It's a hearing matter. No. No, small matter. A small issue involved, your lordship.
Well, only some time is there because there is a reference today.
That's my lordship.
The court is rising early. 3:15.
Madam, we take it up on Tuesday. Small matter, madam.
Due to paucity of time, the hearing could not be taken up. list the matter again on Tuesday, did you? But Thursday.
Thursday, 5th.
Deeply obliged.
Yes, what is this?
We have filed an affidavit in reply today morning.
Today morning? I'll post it next week.
My lord, because there is a stay of my suit since last 1 year. So my lord.
So I'll post, but he's filed the reply today.
Yes.
So I'll post it next week. You
Ma'am,
give a date whenever you
Yes,
want.
yes.
Your name?
A.D. Chaudhary.
Mr. A.D. Chaudhary, learned counsel for the appellant. For the
Yes,
petitioner, submits that an affidavit of reply has been filed today. Stop. However, the same is not available on record. Let registry verify and place the same on record and list the matter on
5th, my lord.
on such
Obliged.
and such date.
Obliged.
Your Lordship, my lord, in this matter, the service is complete. My friend appeared for
Mr.
all the
Barbhuya,
Yes, my lord.
you're appearing for all?
All my lord.
Service complete?
My lord.
There's a stay.
Yes, my lord. Stay, my lord. So, my lord, date may be fixed, my lord, for admission hearing.
Mr. A.M. Barbhuya, learned counsel, enters appearance on behalf of respondent number
My lord, all the respondents.
for all the respondents. Stop. In view of the no, as such, service stands complete.
My lord.
List this matter for admission hearing on 11 September.
My lord.
On 11 September.
Obliged.
Anything else? All done?
Deeply obliged.
Lordship, item number 40, there is an interim order that to be made.
Item 40, interim if any. Mr. Dhar, interim is there? Till date. Interim if any shall continue till the next date of listing.
Yes.